Maybe
But TATE, it is not from TATE 2016 recruitment person comes. Without TATE, there cannot be any 2016 recruitment person.
Next judgment, Mr. Diwali.
Well, in this judgment, my lord, if lordship, my lord, kindly see, my lord, paragraph 12 once. What 12 says, my lord? It says, my lord, meanwhile, the order of the Honorable Single Judge dated 27th August 2021, passed in WPA number 265 of 2019, was challenged in appeal in matter number such and such. Division bench number 4, by order number such and such, only dispose of the appeal, setting aside the, not only dispose of the appeal, setting aside the order dated August 27, 2021, but also dismissed WPA 265 of 2019, which was being regularly taken up by the division bench number 1, that is the Honorable Chief Justice. The DB number 4, while disposing WPA 265-2019, held as follows. Now, we'll kindly see last. Since we don't find any element of public interest, the order impugned dated August 27, 2021 cannot be withstand, and the same is set aside. The instant appeal is such and such. In view of the finding recorded above, the writ petition being numbered is also disposed of. There must be a limit of fraud. These are the instances of fraud.
Next with judgment, Mr. National Fertilizers.
Now, we learned in National Fertilizer. Paragraph 2006, volume 5, SCC 493.
Yes.
2006, volume 5, SCC 493. My lord, paragraph 23, 24, and 26.
On the point?
On the point, my lord, that recruitment rule was not followed. My lord, running page 27 of this spiral binding.
Yes, next, Pramod Kumar. Paragraphs.
Now, my lord, the next judgment is, my lord,
Pramod Kumar.
Yes. 2008 7 SCC 153.
Status.
Paragraph 29, 30.
30.
Paragraph 29, 30, and 31.
Identical issues.
Identical issues.
Next, Krishna.
Now, my lord, next, my lord.
Krishna Jawada.
Now, my lord, 1994 4 SCC 165.
Yes.
Now, my lord, kindly, my lord, allow me, my lord, to place these paragraphs. Yes.
Paragraphs?
Paragraph, my lord, I'm just placing to your lordship, my lord, paragraph 16 to 21 and 23. Page 40.
Yes.
My lord, kindly allow.
On what proposition?
This is the, my lord, identical case with this case.
So very good. We shall look into it.
Kindly, my lord, one paragraph. My lord, kindly, may I just place it?
Which paragraph?
Paragraph 16, my lord, kindly see. Paragraph 16, 17, and 18.
Page, running page?
Running page 49, 49.
Yes.
It says, my lord, having regard to all above, the irresistible conclusion is fraud has reached its crescendo. Deeds as sole of this as inconceivable, much less could be perpetrated. We are.
Achha, don't remind us Shakespeare. Let us go to the next.
Now, my lord, next paragraph 17. My lord, can you have a look? Paragraph 17 and 19. If you lord, I am not pressing it. Now, my lord, next, my lord.
Yes. Vishwaranjan Sahu.
Vishwaranjan Sahu and, my lord.
Paragraphs.
That's page 53. Like this, sir. Like this. This is 1996 5 SSC 365.
Yes, paragraphs.
Paragraph 3. This is, Lord, in respect of, Lord, principle of natural justice. But it is not an unruly horse. There is. Now, my lord, next, my lord, page 56.
Gunwant Kaur.
Yes.
Paragraphs.
1969 3 SCC 769.
You said 96 3 SCC. Gunwant Kaur.
Gunman Con Milord, 1969, 3 SEC 769, page 56. Page 56. Next judgment.
You have given it 1996
In the index.
in the index.
Sorry.
হবে না এত yes, what is the year?
Milord, can you turn page 56?
1967.
1969, 3 SEC 769.
You have referred 96.3.
Milord, paragraph 14, 15, and 16.
On the proposal.
On the point, Milord, the power of the court, Milord, under Article 226 of the Constitution of India. Milord, 2007, volume 4 SSC, volume 4 SSC, page 54. Paragraph 26, 27, 28, 31, and 32.
Yes, next. 1815 SCC 463, paras.
Milord, 2018-15 SSC 463.
Paragraphs.
Paragraph 24 and 25.
Yes.
2018-15 SSC, page 463.
Then 2010 volume 13 SCC 255, paras.
97. Joseph Purnam.
Paras.
2010-13 SCC 255, paragraph 25 and 27.
আরেকটা কি বললো 10 একটা 3 13 কি সব বলছিল
Now, Milord, kindly text, Milord, next one, Milord.
13 দুটো বলেছে
2010-13 SCC, Milord, 255.
got it.
Yes. Next, Milord, 2014 SCC online Tripura 291.
Para.
Milord, kindly read, Milord, kindly allow me, Milord, to place few paragraphs of the similar facts. Milord, where to 10,000 and more, Milord. Paragraph, Milord. 2014 SCC online Tripura 291. Milord, paragraph, Milord, 102, 103, 116, 117, 118, 119, 121, 123, and 124. Now, Milord, kindly text, Milord, two paragraphs, Milord, I will cite. Milord, kindly turn, Milord, running page 187. Running page 1 only page 187.
Yes.
Now, paragraph 102, Milord, it says, Milord, on perusal of these samples representations, which you have given above, it is more than obvious that the selections have been totally unfair. The manner in which the interviews were held can be gauged from the facts that on certain days, as many as 300 candidates were called for interview. Assuming that after the break of the interview board, sat for 10 hours, that is 600 minutes, and this would give barely 2 minutes per candidate. In 2 minutes, one candidate has to leave, another candidate has to step in the room, which the member of the selection interview board be asked to take a seat. The 2 minutes will be over during this process and it is obvious that the interview were a total sham. Now, my lord, kindly text me, lord, the page, paragraph 116, page 190.
Yes.
Now, my lord, may I just place it? Paragraph 116. We live in a country which is governed by the rule of law. The action of each and every official or the government functionaries has to be in accordance with the Constitution. The rule of law is the golden thread which runs through our Constitution. The two most important facets of the rule of law are fairness and equality. Every citizen has a right to equal opportunity of employment and equal treatment at the same time of selection. Nobody can deny this right to any citizen of the country, and if such right is denied, then this court will step in to ensure that justice is done. Next, Lord, paragraph 117. Paragraph 117, I am not reading the entire paragraph. Kindly take note, paragraph 117, last 6 lines. In the present case, the sentence starts with, my lord, in the present case, the less said about the selection process as better. We, with regard to every category of teachers and with every subdivision and division, have been given example which clearly show that there is no method followed by the state in making appointments, and it is more than apparent to us that the appointments have been made on totally extraneous basis without considering the future of the poor students or aspirants of unemployed youth. The whole selection process was a cruel joke on the youth of Tripura, but it is also a cruel joke on the youth of West Bengal. Now, paragraph 118, it says, Lord, that this country, it has to be developed that needs great teacher. The teachers are gurus, and teachers are the guides. The teachers are the mentors, teachers are the philosophers, and it is these teachers who will hold the finger of each child, teach the child, and then lead to the child towards the hopefully a bright future. If the selection of teachers is unfair, then we are headed for a society which will be an unfair society.
So ultimately, what the court did?
Now, ultimately set aside. Entire selection was set aside. Now, kindly on page 192.
Yes.
Relief. It starts at page 191. Page 121, relief. 191, bottom. Has you also got in?
Yes.
It has been urged that even if we set aside the selections, our judgment should be the prospective in nature. It has also been argued by Shankar Dev's senior counsel for the petitioner that those portions of the policy which are bad may be severed, and those portions which can be upheld can be retained. But the appointments already made need not be disturbed. Reliance has been placed such and such, such and such. These judgments have no applicability to the cases in hand, and we are not at all in agreement
So
with this.
was this challenge?
Yes, Supreme Court upheld it. Next, that is, my lord, page 196.
(196) is against this judgment.
Yes. 2028 SSC, page 6. 2028 SSC, page 67.
How can that?
Level page 198. Your lordship would find, my lord.
Just judgment.
Well, this is, my lord, famous or infamous of Tripura 10,000 teachers recruitment scam.
May 2014. 7th May 2014 order was assailed.
Yes.
The cost title gives
But
the
different appeals were filed, my lord. Subsequently, the My lord, kindly see, my lord, page 198. Your lordship would find, my lord. This is the appeal, my lord. Your lordship would find paragraph 2. It says, my lord, selection of 10,323 teachers made by the government of Tripura pursuant to the advertisement issued in 2002, 2006, 2009 was subject matter of the challenge before the High Court at Tripura in Tanmay Nak.
Which paragraph you want citing on this?
Now, my lord, in this judgment, my lord, Supreme Court, my lord, endorsed the view taken by the
Very good.
Tripura.
Give us the relevant paragraphs now. 2020 volume 8 SCC page 67.
Paragraph 17 and 18.
Very good. Next.
My lord, may I just place the paragraph 17?
No, we shall go into that. 17 and 18. We have taken note. Yes, next one.
Next one, my lord, 2010 10 SCC 677. Page 208 of this compilation.
Yes, paragraph.
Your lordship will not allow me, my lord, to place this judgment, my lord, as because, my lord, in this judgment, my lord, 160.
I don't understand. After this also, if you don't see the, tell us the paragraph.
Paragraphs is, my lord, 26 to 37.
Yes, you tell us that.
26 to 37. Well, one paragraph, my lord, kindly have a look, my lord, page 217, paragraph 37. It says, my lord, section 165 of the Evidence Act 1872 empowers the court. Paragraph 37, my lord, page 217 at the bottom. Your lord should get it.
Yes.
Now, my lord, it says, my lord, section 165 of the Evidence Act 1872 empowers the court to ask the question relevant, irrelevant, related, unrelated to the case to the party to ascertain the true facts. The party may not answer the question, but it is not permitted to tell the court that the questions put to him is irrelevant or the facts of the court wants to ascertain are not in issue. The exercise of power is necessary for the reasons of that the judgment of the court is to be based on relevant facts which have been duly proved. A court in any case cannot admit illegal and inadmissible evidence for basing its decision. It is an extraordinary power conferred upon the court to elicit the truth and to act in the interest of justice. A wide discretion has been conferred on the court to act on the exigencies of the justice required. Thus, to discover and to obtain proper proof of the relevant facts, the court can ask the questions to the parties concerned at any time and in any form. Every trial is a voyage of discovery in which the truth is the quest. Therefore, the power is to be exercised with an object to subserve the cause of justice and public interest, and for getting the evidence in aid of a just decision and to uphold the truth. The purpose being to secure justice by full discovery of the truth and accurate knowledge of the facts. The court can put questions to the parties except those which fall within the exceptions condensed. So, my lord, learned judge was absolutely right in asking the questions, and my lord, just to reveal the truth. My lord, your lordship, my lord, kindly consider, my lord, today one thing. My lord, the symbol of justice.
Finish up these two, then you say. 1414 SCC 745.
Now, my lord,
this is paragraphs.
This is, my lord, page 234. Paragraph 16, 19 and 20.
16,
this is 2014 14 SCC 745.
Yes, para
16, 19 and 20. My lord, this is for the ratio, my lord, the meritorious reserve candidate. My lord, a person who is a meritorious reserve candidate should always be treated as unreserved candidate.
Yes.
My lord, last judgment, my lord, that is State of West Bengal versus Boishaki Bhattacharya.
Yes, para.
My lord, it is, my lord, paragraph 43, my lord, you will also get it at page 258.
43.
43. It deals with, my lord, delay, laches, and natural justice. My lord, Supreme Court also said that in these kind of cases where the fraud is apparent, the delay, laches, and natural justice should go. My lord, it says, my lord, paragraph 43 and 44, my lord. I'm sorry, my lord, I should have pointed out paragraph 44 also. 44 says, my lord, it says, my lord, we are of the opinion the principle of natural justice cannot be invoked to validate the fraud that has occurred. The principles are to be rigid and inflexible. Rather, they must be applied with due regard to the specific facts and circumstances of this case at hand. So, my lord, your lordship knows these facts. I am not placing this so far as this judgment is concerned.
Thank you.
Now, my lord, only one thing, my lord, I'll just show to you, I'll just point out to you, lordship, my lord, that
It has been what more you want to show?
My lord, I just want, my lord, the so far as justice is concerned. Now, my lord, initially, my lord, the justice, my lord, your lordship note the 2024, the new version of justice has come. My lord, previously, my lord, it was, my lord, well, your lordship knows, my lord, as a blindfold with a, my lord, sword. Now, my lord, it is, my lord, scale with a constitution. This symbol has changed. Now, my lord, earlier, my lord, your lordship knows, my lord, the a blindfold was put. Well, judges cannot see anything. Now judges are seeing everything. My lord, apparent, my lord, so far as, my lord, this selection is concerned, my lord, your lordship is seeing everything. What is going on? What has happened in so far as selection is concerned? Yes.
Thank you. Yes, who is the next person in line? Yes.
And my lord, other thing, my lord, your lordship, my lord, kindly consider one thing, that so far as, my lord, that Shakespeare's Hamlet, my lord, that something has happened, something has rotten in the state of Denmark. My lord, everything is rotten in the within the administration of my lord board. So, my lord, this selection rightly set aside by the learned judge. And my lord, so your lordship, my lord, kindly consider one thing, my lord. So far as, my lord, relief is concerned, my lord, kindly consider one thing. Today, my lord, learned judge, my lord, set aside the entire selection process. And learned judge, my lord, directed the board, my lord, to start de novo from a particular point. My lord, I would be submitting before your lordship, my lord, appoint, my lord, any other agency, not this board. My lord, Mr. Ananda Mitra also submitted the same line. Your lordship appoint, my lord, national testing agency or any other agency. Lord, this board cannot be trusted under any circumstances. And my lord, if your lordship, my lord, kindly see, my lord, there are so many number of, my lord, applications are filed. In those applications, my lord, number of persons, my lord, cross the, my lord, cut-off marks fixed by the board.
Yes.
My lord, in my writ petition, my lord, out of 130, out of 40, my lord, I can show to your lordship, my lord, 38%, my lord, cross.
You are representing, tell us. Then we will take note of that. Your brother is representing 5. You are representing whom? Tell us.
My lord, I am just assisting your lordship. Nothing more, nothing
This is
less.
not assistant, then you ought to have made the entire argument.
Well, I am really thankful to your lordship for giving such patience hearing.
We need assistance, Mr. Tiwari.
Well, I tried my level best to assist your lordship.
That we have heard you, but at least I have not seen that there is part argument, compartmentalization, appointment.
That has been, theory has been borrowed from the president of the board.
Anyway, thank you. Yes, who is in next? Yes, sir. Yes, sir. So we have to adjourn for your senior counsel. Then start, sir. Please start. Achha, please start. Tell us what is that. Sorry, you please start. Please start. Ask your senior to come wherever he is. এটাকে বেঁধে রাখো।
Kanoshko, that is can application 5, 6, 7 and 10.
Yes, you are for whom?
And there is a can.
You are appearing with whom?
For can application 5 for Priyanka Noshka, that is the main petitioner before the single bench, my lord. those who have preferred appeal subsequently. And this is the board's appeal. We have made the application before your lordship that addition of party, that is can 5.
Can 5 of
It is arising out of 890.
8, 9, 10. 8, 9, 10 of what?
That is the board's appeal, my lord. We have added as a party in the can 5. We are for the applicant because the Priyanka Noshkar.
Which applicant? Which can application? When affirmed? When affirmed? Wait for the application.
Our application has been affirmed, my lord. Can 5 to them. 890.
We are dealing with 150 applications. Please show us your application.
Our application.
You don't know when it was affirmed. Date of affirmation ta bolle oi application ta
This was affirmed on my lord.
Can 890 can
26
can 5.
9 2023. 26 9 2023.
26, 9, 20, 24.
3.
And when was it allowed?
It was allowed on
What is the date of the order? You should have kept it in touch with you. You sit down. Are you leading him, Mr. Mojumdar?
Yes.
Then you start your argument, let him give the text later. Yes.
Two things are essentially required to be addressed by your lordships. What the authorities were required to do and what is the fallout of non-observance. And whether in the given circumstances of the case, the conclusion arrived at by the honorable single judge is a possible one. And this may not I'm sorry.
Yes.
And this not in the teeth of the various revelation which had come out in course of the proceedings, vis-a-vis the observance thereof by the parties through filing of affidavits.
Yes. Yes.
Now, time and again, your lordships have been taken not through the rules. Not I won't trap your lordships with the rules. But not the primacy of the rules was aimed at maintaining a process of selection and selection to find out the best possible candidate. And not in various places of these rules, there is conscious use of the word panel at some places and panels at some other places.
Yes.
But I believe it would not be anybody's case to adhere to the provisions of the General Clauses Act and say that this panel would also include a plural. Because not panel means a list of names of the eligible and selected candidates for appointment as a teacher in primary schools published by the board. So the duty to publish a panel is vested in the board. Per contra, the language employed in somewhere else in the rules where it says that panels are to be prepared. So preparation of panels at a different level is not the panel to be published.
Yes.
But the board was categorical in its stand in the opposition that it has not published the panel.
No, they have not said that.
But the opposition I shall come to.
They have not said that
There is an
we have
opposition.
published.
Yes, yes,
The
there is.
form may have been disputed.
There is an opposition to the writ petition where they have said that we have not published the panel.
Show us that.
Page number টা বার করো।
Which affidavit you are referring to? That panel was not published.
এখানে পাবে না সৈকত, যেটা পেজ নাম্বারটা ইন্ডিকেট করে দিয়েছিলাম।
So your argument was that one panel was to be published. May not be that the preparation of the sub panels of subcategorization also needed publications.
Now please come to the rule.
Yes. ওইটা যেটা দিল ওই কপিটা একটু দে। আচ্ছা এখান থেকে নিয়ে নিচ্ছি। Yes, rule 6.
Yes, please come to, straightway come to note 2.
But ask him to find out where is that
Yes,
statement.
yes, not a,
Note 2.
note 2 of rule 6.
অ্যাপ্লিকেশনটা বের করেছো না? পেয়েছো কি? ও
Not necessary. Not straightway comes to rule 8. Rule 8. I'm sorry. Eight. But I straightway take your lordship through sub rule 5.
Yes.
The selection committee shall prepare separate council-wise panels as per procedure below. Firstly, the selection committee shall segregate all eligible candidates applying for earmarked vacancies as mentioned in note 7 to rule 6 from other successful candidates. Secondly, the selection committee shall prepare the following panels for successful candidates who have applied for non-earmarked vacancies. A panel of all selected candidates in a district, namely unreserved category. So a panel for unreserved category comprising of the names of the candidates belonging to general category and reserved candidates of the scheduled caste category, scheduled tribe category, OBC A category, OBC category and PH category according to descending order of merit as per existing vacancies medium wise. So a panel in each district category wise and medium wise.
There is no obligation to publish this.
I'll show. Not good. Of course there is. Then please come to B.
Now you said that there is a provision for publication of one panel, but separate sub-panels was not required.
Now, how a panel is to be prepared?
No.
What is
Was
to
that your argument?
What is to be published by the board? All
Yes,
these panels come to board.
We don't know. What is your
Board-
argument?
No, these have to be published. All these panels have to be published.
You just now said that preparation of segregated panels does not require
Is
publication.
one panel each. So there has to be one panel which is to be approved by the board and published. Not how these panels have to be. It is not a single panel. Our panel category wise, medium wise. This has to be published once approved by the board. Our panel in a different category, which has to be published once again by the board. Please see the next one. Our panel, it's not a single panel. There are several panels to be.
Yes.
A panel of selected reserved category candidates in a council, namely scheduled caste, scheduled tribes, OBC A category, OBC B category, and physically handicapped candidates in the respective category as per statutory reservation rules from amongst the remaining candidates of such categories serially according to descending order of merit as per existing vacancies in medium wise. 3. A panel of selected candidates belonging to exempted category, ex-servicemen and physically handicapped in a council, separate panels category wise for vacancies reserved for the reserved respective categories.
Yes.
3A. 4. An alternative set of panel of selected candidates for each category in a council, serially according to descending order of merit as per existing vacancy medium wise.
Now, what is their statement in opposition? All right, come to your next point.
Note, such an alternative set of panel, please see.
Yes, we understood. Yes, what is your argument? There was no publication.
A set of panel of selected candidates for each category in a council. Then note 2, separate sets of panels for all selected candidates applying for earmarked posts as mentioned in note 7 to rule 6 shall be prepared in accordance with the procedures mentioned in clauses 1 to 4 of sub-rule B. Then note 6 is an additional panel. So note all these prepared panels category wise and medium wise depending on the vacancy position, apropos the reservation policy or the laws as applied in the state, have to be prepared by each council.
Yes.
And these go to the board for approval. These go to the board for approval. Please come to the next one. Sub-rule 7. While preparing the panels mentioned in sub-rule 5 and sub-rule 6 above, the selection committee shall at first divide all the candidates who will be found eligible after the interview into 2 categories, trained and untrained, and thereafter 2 separate sets of panels for each category.
Yes.
Shall be prepared, one for the trained and the other for the untrained candidates. So, for each district, category wise and medium wise, there has to be at least 2 panels prepared.
Yes.
Notwithstanding anything contained in any of these rules, the impaneled trained candidates shall be absorbed first against the sanctioned vacancies, and thereafter the untrained impaneled candidates shall be absorbed against the remaining vacancies. Under no circumstances, untrained candidates shall be given appointment of trained if trained impaneled candidates are available for the respective categories. So for each category, there has to be a panel of a trained candidates panel and untrained candidates panel. preference being given to the trained categories. If the seats are exhausted, then no further chance, then give up thought to the untrained candidates for each category. Approval of then comes not approval of panel. The panels after being prepared. It's not one district, one panel.
Yes.
The panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district primary school councils with all necessary papers for appointment. The district primary school councils, on receipt of the approved panels, shall call the impaneled trained candidates first for counseling for posting in accordance with the vacancies medium-wise in terms of the options exercised by the impaneled trained candidates, and thereafter the impaneled untrained candidates in the following manner. Please see what is to be done next. If a reserved category candidate opts for an unreserved post on the basis of his position in the general list or merit panel, he shall not be taken into account for the reserved category post. If, however, this reserved category candidate opts for a reserved category post as per his position in the respective reserved category panel, he shall be considered as a candidate filling a reserved category vacancy of that category, and his candidature in the unreserved vacancy in the unreserved post shall be filled up from the general unreserved panel or merit list. So there has to be a reserved category panel, there has to be an unreserved category panel.
Yes.
The stand of the board in opposition was, I just read from page 389 of the stay application. I just read it, it's in volume 2.
Yes.
Stay application.
873. Paragraph 9 at page 389. With reference to the statements made in paragraph 10 of the said petition, I say that the applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contended in the writ petition. The recruitment rules has not been challenged in the said petition. Such being the position, respondents cannot be faulted not to have caused publication of the above in public domain.
Where is that provision that you publish it?
Not the definition of panel itself requires a
Code has to
publication.
be published. There is any other published reference to this
No.
point?
All other provisions deal with preparation of panels and approval of the panels by the board.
No, the panel definition says it has to be published in according to the rules. Where is that according to
The rules are silent.
rules are silent? So if rules are silent, what is the obligation?
Procedure may not be there.
Procedure,
the
separate panels.
But the fundamental duty to publish remains.
Where?
Not
Published in, come to the definition.
yes.
Panel means a list of names of the eligible selected for appointment as teacher in private school published by the board according to rules. Rules are silent. Then what will be your argument to
The
that?
procedure for publication.
Procedure is separate. A separate panel wise, as you have
No,
explained.
the procedure for publication might not have been spelled out in the rules.
Yes.
But that does not do away with the obligation of the board to publish a panel in accordance with the rules.
No,
Suppose the rules are not there.
Suppose rules are not
Is it
there,
a- is
they
it
are
an-
taking the plea, we have pasted in the district council.
That is not that will not do, because the board has to publish.
Board has done it, approved
Board
panel
has to
was not
publish the
put.
panel.
But the rule
The-
itself is silent.
The
How
modality of
is-
publication is not prescribed in the rules.
Exactly. So when the modalities are not prescribed, you have to impinge upon them that they have conducted and followed an illegal method.
Right.
What illegal method they have
But
done?
first of all-
Suppose the rules does not say.
First of all, whether these panels had at all been prepared by the councils.
That is separate. That is another aspect
So,
of
but
it.
what is approved?
You are arguing on publication.
One is
Nobody till now has told us, shown us that publication means uploading in the website or it is uploading in the panels. Where?
now
Anyway.
modality of publication is not there.
Silent.
The rules do not spell of a modality of publication.
Modality.
It could be a pasting on the notice board or a conspicuous place.
Yes,
It could be an uploading.
No, very good. Your argument is very good. Nobody has till date told us that they are. This has not been told to us that there does not exist any modality towards publication.
So the rules are silent. That I have to go by the rules.
Go by the rules. Yes.
Now, the panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district primary school councils with all necessary papers for appointment. So, what is approved is
You are going into appointment letter. First criteria they do not fulfill. That is your argument.
it's not. I am trying to draw your lordship's kind attention to a harmonious reading of the various sub rules of the Rule 8
Already we have
which may lead to the only possible inference that there is a duty cast on the councils to prepare various panels, in each category at least 2. One for the reserved trained and the other for the reserved untrained.
Yes.
Otherwise, the subsequent provisions in the rules, which gives a preferential right to the trained candidates to get an appointment and to exhaust the vacancies, this cannot be carried forward or cannot be implemented. And therefore, not comes the question of preparation and disclosure of panel medium-wise, category-wise, and this reservation-wise. How has this exercise been carried forward, fructifying into issuance of letters of appointment in the absence of panels being prepared?
Yes.
Now, the unequivocal stand of the board before your lordship's court is district-wise we have prepared
Statute
panels.
does not mandate us. Statute does not mandate. There is no mandate that you have to publish it in
No.
this fashion.
We have prepared panels district-wise, and I am not on publication for the time being.
No, that you have shown to us.
I am submitting that the
There are two parts. One is publication, the other is preparation. Preparation has to be single panel as the procedure has been laid down.
not single panel.
Respective panels for the
Yes.
respective subjects for the earmark.
Medium-wise, category-wise, and even reservation. Not this has again twofold ramification. One is trained, the other is untrained. Unless one prepares a panel for trained candidates and untrained candidates, then how does one give a preferential right to the trained candidates from that panel?
So we may assume that there is a total nexus. It was one selection process for trained as well as untrained. If no aptitude test is held, then no aptitude test was held for the trained candidates also.
If no test has been held, it has not been held for
Not been
anybody.
held. So today, the judgment, if you can come, just a question.
My lord, of course, not. It helps to shorten our argument or not to reply to your lordship's queries.
A recruitment process is being challenged. It has two parts. One for the trained, other for the untrained. the Honorable Court proceeds on the basis that it is not the writ petitioner's case concerning any trained candidates. So we restrict ourselves to the untrained.
Untrained, right?
So today, if for the lack of aptitude or the other infirmities as have been pointed out by you and others, today we say that this untrained candidate appointment was bad. But on the self-same declared recruitment process which we are asking, which we are being asked to set aside, there will be 12,000 other candidates who would be aggrieved, because then we have to construe that there was no proper aptitude test, no proper publication of panel for the trained also.
There can be two ways of approaching this issue.
Yes, you tell us what can be the issue.
One is,
Again, call the trained persons, come and join, we will consider.
your lordships normally, of course not, your lordships will only decide a lease. A lease.
You tell us, Mr. Mujumdar, how it is to be decided.
Now,
Now, is it then incumbent upon us that I should call the trained candidates also, that see, your employment is also at stake? Because I will be setting aside the entire recruitment process. And the persons you have served, though you are not affected by the judgment, you will now be affected. What should the court do in such a circumstance?
there are instances both ways.
Now, we are asking you
There
to
are
assist
instances
us.
both ways. After all, to court justice higher, the court first decides and then gives reasons.
What is the solution?
The solution, I had filed an application.
One thing is that no, we are not. It is a very serious issue. We are dealing with the life and
Lives of
livelihood of
persons, of course.
33,000
Yes,
families.
yes.
We are asking you that you tell us that then where it is to end. It has not been pointed to us that this is the specific rider nexus of part A, B, C candidate with the corruption. So they must go. It has not yet been shown to us that investigation is continuing. It has not attained final. The unified argument from your part has been that there was no aptitude test. There was total corruption, scam. Now, if the aptitude test goes, the same aptitude test was there for trained candidates.
Trained, of course.
Then what should the court do?
The issue before the court was untrained
So
versus.
if we deliver a judgment today, the point will be then if you are touching the candidates of trained also, because your argument was that without exhaustion of the trained list, the untrained does not come in the picture. So if the trained appointment was totally bad, your exposure becomes more.
Now, the issue before the court was untrained versus untrained.
No, Mr. Mujumdar, you were asking from us that you answered the list. You say whether this sort of a corrupted practice can prevail or not.
I can show to your lordship instances galore.
When you ask something from us, we also have to question you, na, Mr. Mujumdar, that Mr. Mujumdar, you tell us today, if I am setting aside the recruitment process and affirming the cancellation of appointment of 33,000 untrained candidates, am I to leave the trained candidates who also got such appointment on the rudiments of a scam? They will not be touched. What will be the answer, Mr.
Not appearing for
the. Think over it, Mr. Moju. Please think over it.
It's not. That will be a separate issue, of course. Not, of course, very intricately connected. Not what will be the outcome of this?
What does the council say? What? Sir, you people you are the top class of the society. You have to say. The advocates are meant for that.
Not the right side.
Advocates are espousing the cause of the people. One is for the persons who have already got service, worked for 5 years, and tomorrow you say you go out of the employment.
They have worked for 5 years,
and at the same time, you say that we have been the perpetual sufferers. We participated. We did everything. Just because we did not pay money, we did not get appointment. Very attractive argument.
Not in so many words, but
yes, we are expressing what we have.
This. Not a person who got 16 in total, he has got an appointment. I got a particular marks. There are
certainly.
There are 569 persons working from the same district who got less than me.
Appreciate your argument, Mr. Mojumdar.
And
we set aside the entire process.
And this is
vis-a-vis we have to hear the trend also.
And this is only untrained versus untrained.
No, that you cannot restrict.
No,
Mr.
no, no. I am when the example that I shall cite.
Your writ petition was what? There are 369 existing vacancies.
Yes.
I have not been treated equally with my counterpart who happens to be an untrained. You just give me appointment in that post.
Right.
Finished.
Right.
No rumble, no riddles, nothing. Everything would have been quiet.
Yes.
Then what happens today?
Not
We are answering a larger
today.
issue.
Yes, your lordships can't close eyes. You can't close your lordship's eyes to the fact that
We are-
if I go ahead, somebody else who might have got more than me.
Yes, next, what is your, please think over it. I would request all the advocates to do so.
And in so far as the other party is concerned, that investigation by CBI.
Answering a lease is an issue, but at the same time, you have to, you cannot segregate yourself from
No,
the.
Today, if
This
somebody
is
is
a
not before
social
your
problem.
lordships,
This is a social problem.
today, if your lordships, somebody is not before your lordship's court who might have got more than me,
Yes.
might have got more than me, but not been appointed. That is also a possible case.
No, that you can say that even they have not appointment, whatever would be the judgment, it will be applicable to all.
At the
That
same
will-
time, there are persons who have procured employment.
So if we today set
Getting less
aside
marks
the
than me.
judgment and say it is a judgment in rain, then the trained candidates who are not parties will
But-
also be sent out of
But in
employment.
the event your lordships hold that the process suffers from illegality,
Right.
then this should percolate to every possible end.
Exactly. And then we are hearing the persons who would be affected. Without hearing them, we would be doing.
Right. Now,
There is no answer. To the arguments at once. But it is a serious question. As you are saying, how will you see? I got 15 and did not get the appointment. The person who got 9 is being appointed. Really? Heartbreaking in a competitive process. So then this allegation will again be there in respect of the trained persons. Persons will file addition of party application. Just as it happened today, because if we set aside the recruitment process, then all the persons who come inside the ambit, they get a chance to get the consequence of the judgment election which we issue. Similarly, trained candidates also this will happen.
For 10 candidates, 15 months different.
This is just a question which has cropped up. We are seeking an answer from you.
but I shall try to not reply it in my way. But, but not in so far as the trained and untrained categories are concerned, not there are separate modalities of marking. But not this is
Only
apart.
one thing left out, training. Other modality same.
Yes, not so far as the
Yes, why no? Why no? Let us
so
see
far as the
chart.
vivacity and the personality test is concerned, that remains the same.
Thank you for assisting us to that aspect also. We may be wrong also, unless we are pointed out.
But it is there, but not what has not been done by the authority, not doing a wrongful action, causing a large deprivation to us. It's a large scale illegality committed. I'm not, for the time being, since I have not produced the documents or the exhibited materials, I'm not for the time being submitting that it's a fraud. For the time being, I have documents to show that persons who have got 15 marks have been appointed vis-a-vis the untrained category.
If we accept your argument, there's a large scale scam.
Not a scam. I said illegality in
Illegal.
observance of the process. I put it in this way for the time being. And where does it result to, and what is the cascading effect of this? Not one would be, one would be to-
33,000 substituted by another 30.
not one would be to recast the entire thing once again. The whatever is available, recast it.
How can you recast, Mr. Majumdar? 1,25,000 applicants.
Not if there is an illegality.
42,000 selection. Only one judgment has come to us, Tripura High Court judgment, which your brother has just now cited. We shall consider they will answer on that.
My lord,
But our question is, we are seeking an answer that there is corruption scam, this cannot stand. You have to lose your jobs. Then if they are thrown out, these identical riders applied to the said recruitment process. Now the persons who had been unsuccessful as trained candidates, they will also come to us. That, sir, consider my case also. This is the infirmity. Where is the end of it? And remember, in the meantime, their services are continuing.
right? My lord, does that
When if we deliver a judgment, say after 2 years, they would be completing 7 years of service. They become entitled to a part of the gratuity and everything, 5 years. Gratuity, government will be settled
in
for
10
this,
years?
for the wrong which has been committed, as it has been alleged wrong, I should say.
But today, my lord, if your lordships are persuaded to hold that there is a gross wrong, gross illegality,
No, we are
But under-
asking you that suppose we accept your contention and set aside. We cannot segregate, na, that there had been corruption in respect of
a
untrained.
unified process, my lord, that's
Yeah.
undoubted. That's the problem, my lord, which
Then
is,
what can be your suggestion?
but we shall try to not find out a
Nobody has told us that. We are hearing arguments from your part from substantial period. Please consider. Anyway, what are the other points you are arguing?
very good. I'm not, but I was placing not paragraph that rule 10.
Yes.
Come to sub rule 2. If a reserved category candidate opts for an unreserved post on the basis of his or her position in the general merit list,
Mr.
or
Majumdar, this has been shown to
Very-
us.
then not please come to rule 12. Not much has been questioned about the validity of the panel. Before your lordship's court that there has been large scale rank jumping. Then not that will not weigh with your lordship's kind conscience not in deciding as to whether these persons should be allowed to continue or not. Now, trained is one aspect altogether, a different aspect altogether. This is a case of untrained versus untrained.
All right, what is your next point, Mr. Majumdar? Have you drawn up any written argument to
Not
that
not
effect?
till I shall hand up. Not I have formatted the points. There are only 5 or 6 points. Not I have noted it down. An approved panel shall remain valid normally for 1 year from the date of approval by the board.
Hmm.
Provided that the board may extend the validity of such panel by 6 months at a time, but the total period of such extension shall not exceed for a period of 1 year.
They have said that it has expired on diverse dates in between a particular period.
Now, I'm not,
That is there.
there can be no estoppel against me or no waiver or acquiescence against me, because all these things will only operate if there is a known right which I have waived. What has not been disclosed earlier can't operate against me for the purpose of shutting me out.
That is with subject to some reservations, because the litigations continued from first writ petition was in 2019, I suppose, which was disposed of by Justice Banerjee.
17 man.
17. And in that also, in view thereof, whether you can take this plea that I was totally blind about the entire
These
aspect,
things,
in spite of being a party to that litigation.
these things have no. Some of them were not parties of
Some
course.
not, but some were.
Could have been.
No, not could have been, Mr. Majumdar.
There were not. Nobody has kept a count of the number of
No,
applications for
you cannot shun out
impeachment.
that on that basis.
No, nobody has probably kept a count of the number of applications for addition of parties filed in different litigations.
No, they were rich petitioners in those. Justice Orijit Banerjee's judgment is go
That
through
was
it.
for the purpose
I
of
may be wrong, just check it out.
publication of a panel probably.
This argument, panel reservation, this rank jumping which you are saying,
Right.
this was exactly the point in
This
origin.
has now come out. This has now surfaced.
No, sorry, it came out at that juncture.
But they have not. They have disclosed it only for the first time before the honorable single
No,
judge.
no, it was disclosed at that time. That was the council's argument. Have you, Mr. Majumdar, have you gone through that judgment? Justice Banerjee
Yes.
and Justice Bhattacharya.
Right.
Please go through it once.
I have gone through. Now, not this disclosure of materials and not the district-wise numbering. This has surfaced for the first time in this litigation.
No,
In this
subject
round.
to correction.
No, no,
Subject to
that spiral
correction.
binding surface for the first time here.
Please go through paragraph.
I'll go through that.
Paragraphs. Yes. Yes. Anything else, Mr. Majumdar?
No, of course not. I have to satisfy. Not, I can't conclude today. Now, I'm not. Please come to. That trained versus untrained, your lordships were posing this question to me. Please come to that schedule once again.
Schedule of
Yes, now please come to that qualification for recruitment.
Criminal রাখ না হলো
ডেট অফ অ্যাফার্মেশনটা বললে ওই অ্যাপ্লিকেশনটা
This was affirmed on my.
can 890
can MAT নয়
26
can 5
9/20/23.
hmm
26 9/20/23.
26/9/2024
3.
and when was it allowed?
Well, it was allowed on. Mm,
What is the date of the order?
well, I'm giving.
You should have kept it in touch with you. You sit down. Are you leading him, Mr. Mojumdar?
Yes.
Then you start your argument, let him give the text later.
Ah,
Yes.
Two things are essentially required to be addressed by your lordships. What the authorities were required to do, and what is the fallout of non-observance. And whether in the given circumstances of the case, the conclusion arrived at by the honorable single judge is a possible one. And this may not I'm sorry.
Yes.
And this not in the teeth of the various revelation which had come out in course of the proceedings, vis-a-vis the observance thereof by the parties through filing of affidavits.
Yes. Yes.
Now, time and again, your lordships have been taken not through the rules. Not I won't trouble your lordships with the rules.
এইভাবে কেন এগুলো বলছি আমি করছি শোনা কাজ শুনে যাবো আমি বলাতে বাবা
I was told Mr. Bhattacharya would also be arguing. Though I have not recorded it, so if you can just convey so that on that day at least he can start. I think he would be covering the arguments of other persons.
I shall try to
if you
also convey your lordship's views so that if
we
you can come
only
with an
request
answer.
you now, if it can be done, and you give a think over this, Mr. and give an answer. Thank you.
মুশকিল হলো 11 তারিখে বাকি 2PM গুলো কি হবে 11 তারিখে বাকি 2PM ওকে কবে রাখলো দাদা